friends, welcome back to Law Scholars. In this episode, we are talking about the limitations on the exclusionary rule as it relates to criminal procedure. These are essentially exceptions to the exclusionary rule, which we had just focused in our last episode. As a brief review, what the exclusionary rule is simply stating if a search is conducted illegally, that evidence may be excluded at trial. In Silverthorne Lumber Co. versus United States, this also extends to the fruit of the poisonous tree, meaning if the evidence in question was obtained via an illegal search at one point and was validly obtained later, well, then it's still going to be fruit of the poisonous tree and still going to be excluded. So we have several limitations on this rule, though, which means they are exceptions, because there's always an exception when it comes to law school, always. So our first exception is the good faith exception. Our second one is going to be independent source and inevitable discovery. And then our third exception is going to be standing. And then we have some general exceptions that I won't spend a ton of time on, but I will just briefly list them out at the end of this episode. Okay, so let's go ahead and start with our first exception, the good faith exception. This is outlined in Commonwealth versus Johnson. This is a state case. We've got a federal rule for the good faith exception, and then we have a state rule for the good faith exception. What is the federal rule? Well, the federal rule is outlined in U.S. versus Leon, and it says if the officer is relying on objective good faith on a warrant issued by a judge, the evidence may not be excluded. In Pennsylvania, though, the good faith exception is not available regardless of whether or not the purpose of the exclusion is privacy concerns or deterrence. So about 15 states have chosen not to accept the good faith exception. Pennsylvania is one of those, as was seen in Commonwealth versus Johnson. But the general federal rule, which if 15 states haven't accepted it, that's still 35 states who have accepted the good faith exception. If the officers are acting in objective good faith on a warrant issued by a judge, the evidence may not be excluded. That means that you still need to have a warrant, and the judge needs to have mistaken the probable cause. That means that it's a judicial error rather than an officer error, and the officers are acting in good faith on that error. There are exceptions to this good faith exception. So we've got exceptions within exceptions. There are 3 exceptions. First is that the officer gives false information to the judge when they're obtaining the warrant. That's clearly not good faith, because then the judge is issuing a warrant and the officer then is not acting acting reasonably within the warrant or the judge's mistake. A second exception to the good faith exception is if the magistrate is not wholly independent. We talked about this with a neutral magistrate previously when we were talking about our issues of warrants. If a magistrate is out there conducting a search, if they are related to the applicant for the warrant in a certain kind of way, favoring things, and then the good faith exception might not apply there too. Again, this is a judicial flaw rather than officer flaw here. And then the affidavit of the warrant is facially deficient, which means if the information given to the judge is lacking probable cause in the first place, well, then you can't have a good faith exception there. We've got one case here to illustrate this. This is Farmer versus State. In this case, undercover police officers went to a hotel to conduct surveillance in the hotel, and they were checked into the wrong room by the mistake of the hotel staff. Located in the room was some luggage. The officers checked the luggage, and they checked the cabinets, and they discovered illegal drugs within such. Is this a unlawful search? Clearly, yes. Is this accepted by the good faith exception? Clearly, no. Why? Well, underneath the federal law, the federal rule, the exception does not work because it needs to be based on a warrant issued by a judge. And that is not the case here. It was the mistake of the hotel staff, not a judge. There was no warrant to begin with, and so in this case, the evidence should be excluded because the good faith exception is not going to work here. Okay, our second exception to the exclusionary rule is independent source and inevitable discovery. Although seen as exceptions to the exclusionary rule, the independent source rule is essentially infers that the prosecution would have obtained the evidence even without the improper search of the officers. In other words, because the evidence would have been obtained lawfully in a subsequent discovery request or through inevitable discovery later, the material is not going to be excluded. You have a case here, Warrenberg, I'm not sure how to pronounce it, versus State. What happened here is that this is basically the fruit of the poisonous tree. The officers had conducted a search previously and discovered materials for manufacture of illegal drugs. And then later they had gone and searched it a second time and found more illegal drugs. The independent source exception allows evidence initially observed during an unlawful search, but later obtained through an independent means. With that said, I actually can give some better details about the facts here. What happened is that the officers had an arrest warrant, and they went into Warrenburg and executed the arrest warrant. As they were doing so, they had made some other discovery of drugs. And so based off of this, they went and conducted a full search of the evidence that would have been outside the scope of the original search. Now, the question here is, this material was initially observed during an unlawful search, but later they did obtain it through independent means. An independent source is evidence derived from a lawful source if, apart from the illegal conduct, is admissible. That means if you would have found this anyways through lawful means, if you take away the illegal conduct and you still would have found it, well, then it is going to be admissible because at that point it's not fruit of the poisonous tree. Inevitable discovery is if the evidence would have been discovered, then it is going to be admissible. If the evidence would have been discovered, if it had gone through the correct means, well, then it's still going to be considered admissible. The connection to the evidence is going to be hypothetical in this case, and that's why it's an issue, based off of the first search. Only 2 states have rejected the inevitable discovery doctrine. That is Washington and Texas. Okay, so we have a case to illustrate the inevitable discovery doctrine. This is Nix versus Williams. Williams was suspected of abducting a little girl and then disposing of the body along the side of a road. Quite a few miles and actually quite a few towns away from the abduction site. A search party was sent out to find the body. Illegally, the body was found because Williams had confessed to the location of the body. At the same time the body was discovered, the search party was about 2.5 miles away. So, what happened here? Williams confessed to the body. A search party was already out there. The search party was 2.5 miles away at the time of discovery of the body. And so now the question is whether or not the search party would have discovered the body inevitably anyways. And this is also a little wrinkle here, is that there was a storm coming in, so the search party might not have been able to continue searching for much longer. The body was discovered near a drainage ditch, which the search party was instructed to search. As far as where to emphasize their searches was near drainage ditches. So this is an example, as I mentioned, of the inevitable discovery doctrine. This was, in this case, inevitable discovery, and so the body here can be used and admitted as evidence against the defendant. This case also shows how broad that doctrine is. Despite the potential discovery of the body, meaning the impending snowstorm, and the distance of 2.5 miles, the doctrine was applied, and the evidence here was not excluded and used to convict Williams of the crime. Okay, let's talk about another exception. We have standing, and our case here was State versus Bruns. What happened is that the officers had conducted a traffic stop, and let me just double check my facts here. Excuse the delay. I just want to double check that I'm making sure that I'm saying the right facts. Okay. Yes, so what happened here is that Edwards was pulled over in a traffic stop and arrested after the officers had discovered that there was an outstanding warrant against this individual. Evans was a passenger, and the only passenger in this vehicle, and Evans was placed in the back of a patrol vehicle. The officers opened the glove compartment and discovered a toy gun, although it appeared real at the officer's first glance, and they also discovered a knife. This evidence was connected to a bank robbery that Evans and the current defendant Bruns had committed a week earlier. So this is a case against Bruns, and now the issue is, can this toy gun and this knife be admitted as evidence against Bruns, even though Bruns was not in the vehicle at the time of the discovery of that evidence? So that is really the question of where this is at. Now, let's talk about the rule of whether or not this evidence can be admitted. Well, in New Jersey, let's talk about standing, because it's a matter of, does this person have standing to be there? Standing is defined as an interest that is substantial enough to say that the person was aggrieved by the unlawful search and seizure. In other words, can Bruns challenge this because he has enough standing to challenge this being aggrieved of the actual search? In New Jersey, the place where this case had happened, to establish standing, the defendant must show first that there was a propriety, possessory, or participatory interest in the place searched and the item seized. So he needs to show this interest in both the toy gun and in the vehicle. Second, the defendant needs to have had a reasonable expectation of privacy in these locations. The federal standard is only going to ask the reasonable expectation of privacy element to this. It's not going to ask the propriety, possessory, or participatory interest. After working through both the federal and state standards for standing, the court applied the test to Bruns. In Bruns, he had no standing because the alleged robbery happened a week previously, so he has no interest in those items presently, and the defendant has no interest in the location where the items were discovered because this was Edwards' car. This was not Bruns' car, this was Edwards' car. Also, this case does not explore the legitimate expectation of privacy, which is the federal test. So let's just briefly explore the federal test. Does Bruns have an expectation of privacy in this vehicle? The answer is going to be no, because again, this is the car of another individual. This is not Bruns's car. Bruns does not have an expectation of privacy within this car because it's not his. We have one more case to illustrate this. This is Minnesota versus Carter and Minnesota versus Olson. Again, these are combined cases, so we'll just give the facts of Minnesota versus Carter. Carter and Johns were at a party for 3 hours, and the officers were tipped off of illegal drug activity ongoing at this party. While the officers were preparing for a warrant, they were observing, and they observed Carter and Johns leaving the party. The officers then pulled over Carter and Johns, searched their vehicle, and that revealed illegal drugs. Based off of this, later the house was searched, more drugs were found, and that matched the ones that were found in the car. There was a scientific match there. The challenge here is whether the evidence derived from the search of the house could also be applied to the defendant, it not being part of their house. So the court says that there is no standing, meaning that the defendants cannot challenge the evidence seized at the house because there was no reasonable expectation of privacy. Why? Well, they were in the house for a short period of time. They were in the house only for business. And then, honestly, the officers were observing the party going on through the window. So there was no expectation of privacy there because the officers standing outside could see what was going on. So even if there was standing here, though, so they didn't have standing to challenge it. But let's say that they did have standing to challenge it. Would the search still be considered valid? The answer is probably yes, and the evidence could be used against them. They were at the party for an extended period of time. The search in the vehicle was clearly valid, and then the search of the home was executed by a warrant afterwards as well. Let's talk about State versus Hess. Essentially, the holding in there is that a repeat overnight guest may have standing. How's this different from Minnesota versus Carter? Well, the person was only there for a few hours, and so they didn't have standing to challenge the admission of the evidence. But in Hess, the person was an overnight guest, and they did have standing to challenge the evidence. Those are our three primary methods of limiting the exclusionary rule: the good faith exception, the independent source, and inevitable discovery, and then standing. We do have some other exceptions. In Calandra, there are grand jury proceedings. No evidence needs to be excluded to grand jury proceedings because the material is not being presented to an actual jury at trial. Reason for this is because there's no deterrent effect when presenting to the grand jury, because the evidence presented to a grand jury is still not going to be admissible later. So you can you can still admit that evidence to a grand jury. We have Lopez Mendoza, which says that the exclusionary rule does not apply to administrative hearings, such as immigration hearings. These are not criminal hearings, and for that reason, the exclusionary rule does not apply. In U.S. versus McCrory, sentencing. The exclusionary rule does not apply to sentencing. Judges should be given all the material available when they are deciding a sentence, so the exclusionary rule does not apply. And then finally, we have United States versus Havens, which says the exclusionary rule does not apply for impeachment of a witness. Impeachment is when the witness is saying something, you can then present evidence to counter what that witness is saying. The exclusionary rule does not apply if the purpose of the admission is to impeach the defendant and only the defendant. Okay, so that's everything as far as the limitations on exclusionary rule goes. A lot of material, but some good stuff all the same. All right, have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.